Hey, everybody. I'm so glad to have you with us here today. I am Jill Escher, and I was co-chair of the Autism conference at Stanford last week, where unfortunately we ran into technical glitches and weren't able to record the live presentations by our esteemed presenters. So this is a recreation of what was offered at that conference at Stanford on October 15th. And I'm very pleased to present today Kevin Urbatsch, who is a very well-known estates and trusts attorney who knows so much about estate planning for special needs. He's based in Berkeley here in California. And without further ado, Kevin, please take it away.
Thank you, Jill. So what we thought we would talk about today is estate planning for a loved one with special needs. And basically, when we're talking about estate planning, a lot of times families get a little confused about what that means. So primarily what we're really kind of focused on is how do we do a plan for what happens if, say, the parents are unable to take care of a loved one with special needs anymore, or sometimes it's a spouse or whatever. So I'm going to go through some of the biggest issues that we see arise in doing estate planning, kind of give you some heads up. We have materials that we cite to in here that can help you kind of navigate this very complicated area. So when we're looking at doing planning for a loved one with special needs, our overall goal, our main goal is about enhancing that person's quality of life. We want to make sure that we're giving them as much money and assets and care and housing and all the great things that they need to enhance their quality of life to the maximum extent possible. And part of this plan will then obviously take into account financial security. What kind of money is there going to be available for a person with a disability or a loved one with special needs? And as we get into this a little bit, we'll further define what we mean by loved one with special needs, because a lot of what we're focused on is making sure that any public benefits that person's entitled to, that they continue to receive, even if we have to set aside some money for them, basically to supplement whatever's available from public benefits. But a lot of estate planners who don't really work in this field forget about the bigger part of the planning picture, which is really who's going to be managing the care for that loved one. A lot of times families think, it might be a sibling or another family member, but it's quite a burden that you're giving them as far as managing the lifetime care needs and financial security needs of a person with special needs. So a lot of times what we're focused on is making sure that we have the right people in place and enough flexibility in the plan, as far as changing circumstances. The other thing to remember is housing. Sometimes somebody might be living in a boarding care. Sometimes they're living at home with the parents. And we have to kind of figure out and think about what happens if the parents aren't there. Is that person still going to live at home? Do we need to provide additional supports? Or might they be moving to a boarding care or some other living arrangement? So it's something that needs to be thought about and discussed. And as most parents know who have a loved one with special needs, you basically have become their advocate. And it could be an advocate for obtaining public benefits. It could be an advocate for schooling. It could be an advocate for just about anything. And when mom and dad or the person who's primarily responsible for taking care of that loved one is gone, we lose that advocacy. And so we want to make sure that when we create a plan that we continue that, because again, it's very easy for a person with disabilities to be subject to predators, as we identify, or subject to undue influence, or maybe not receive the benefits they're entitled to just because we don't have a strong advocate. Again, one of the other biggest issues that we deal with, in addition to housing, is the caregiving. Those are usually the two bigger items of care that we need to kind of focus on. What is lifetime housing going to look like, and what is about lifetime caregiving, or could be a care manager or some kind of support system put in place? Once we kind of have a handle on that, We also want to think about, what about other family members? Might they want to leave money to that loved one with special needs? We want to make sure that there's a place to put that money that won't interfere with that beneficiary's plan that we've put in place that might preserve their public benefits, provide advocacy and housing supports and caregiving. So we want to make sure that this is all kind of coordinated with all the family members, basically having a clear set of instructions for how to leave money to a loved one with special needs. And then usually at the end of all of that planning, we also think about who might inherit the money when that person with a disability dies. And so that's kind of, in a nutshell, what we're doing with estate planning for a loved one with special needs. So I'm going to start with a little overview of public benefits. And here's kind of the big kind of 10,000 foot view of public benefits available for a person with a disability. And you'll see at the top, I've broken it up into needs-based public benefits, entitlement public benefits, and kind of an other public benefit program. And the reason we do that is because each public benefit program typically has its own set of criteria for how to be eligible, and also might have different entities responsible for managing it. And a lot of times you, as the parent of a loved one with special needs, is kind of going to have to become a bit of a public benefits expert to know which benefits your loved one is receiving, which ones they should be receiving if they're not, what those benefit programs provide, and then again, a lot of advocacy inside this whole slide. So looking at the needs-based public benefits, we spend a lot of time on this in planning because oftentimes our clients are unable to work. And if they're unable to work because of their disability, or maybe they can only work a little bit, then they might qualify for something called supplemental security income, or SSI. And we'll talk a little bit about SSI in more detail. But in general, that's kind of the introductory special needs program that a lot of our public benefits program that a lot of people receive who are disabled, and it might be the first one they receive. And the benefit of SSI is you qualify for it, you automatically get Medi-Cal. Nationally, it's known as a Medicaid program. In California, we call it Medi-Cal. And part of the Medi-Cal program, then also we can get additional benefits there. And usually that's through in-home supportive services, or IHSS. And that can provide in-home care. So again, a lot of times we're focused primarily on that in-home care and the Medi-Cal and the SSI. And the reason we call
Kevin, I'm gonna butt in just for a second, because this is a really big deal for our audience, and some of them who are new to it don't really wrap their heads around it. You know, SSI often can provide, you know, let's say somebody turns 18, you know, let's say $700, $800-ish a month. The IHSS, the in-home supports that they can receive, can be 5 times that much easily. Yeah. And often people don't think about that, but that is actually the much, you know, meatier benefit for most people in our circumstances.
Yeah, and in-home supportive services is a great program. IHSS, so it's again related to Medi-Cal, and it is focused on the individual's ability to live in the community. And if they need some support or assistance, caregiving support to live in the community, then the IHSS, they might qualify for IHSS. And usually what will happen is the county will send out somebody, they'll do a report, they'll figure out what kind of hours they may need from a caregiver. And then once they receive that, you know, notice, usually they'll figure out the number of hours. And I think the maximum hours you can receive in a month is 289 hours, which is not 24/7. And even though some people may need 24/7, the state won't pay for that. And a lot of times the IHSS benefit, the worker can also be the parent. And that might be where Jill's referencing, that the family, you know, the parent who's taking care of that loved one with special needs can get a paycheck from the government to do so. And one of the things we'll talk about,
possibly without having to pay taxes on that income.
Correct. Yep. And that income, could become income tax free. So there's a lot of really nice benefits that go along with making sure that they're getting everything they're entitled to. Now, we'll talk a little more detail about SSI, a little bit about Medi-Cal, not as much about IHSS, but maybe I should have. So entitlement benefits are same but different. And this is a big distinction because there's a program called Social Security Disability Insurance, SSDI. And a lot of people will tell us, oh, I think we're on disability. And, we have to sit down and figure out which program are they on, because SSI, Supplemental Security Income, and SSDI, they're both run by the Social Security Administration. You get the checks from the same people, but they have completely different eligibility requirements, and managing them is completely different. So Social Security Disability Insurance, somebody would receive if, say, they worked for a period of time, paid into the system, and then became disabled themselves. And sometimes that's possible. They might have been working for several years and then became disabled through an accident, injury, medical malpractice, something like that. And I like to say that, I used to say Bill Gates, but I guess I have to say Elon Musk now. I guess get fresh material. Elon Musk would qualify for Social Security disability if he met the definition of disability. And that is important because they don't care how much income or assets you have. You just have to have paid into the system long enough and meet their definition of disability. So that's a really nice benefit because I like it because I tell my clients, we can't screw that one up when we're doing estate planning. One of the biggest missed benefits I see is childhood disabled beneficiary benefits. Sometimes you'll see it referred to as DAC, or disabled adult child benefits. This is an interesting program because the person with a disability may have never worked, may be disabled, have been disabled through lifetime, never paid into the system. But if they meet the requirements for this program, they can get a 50% of what the parent receives once the parent becomes disabled themselves or retires. And usually that's a much bigger check than what SSI pays. And again, it's one of those checks that they don't care about resources. They only look to the person's eligibility for the program. The other benefit of both SSDI and CDB benefits, if you're on them for over 2 years, you also qualify for Medicare. And generally, if somebody's on Medicare, they might also get Medi-Cal, so they might get both programs, which presumably is the best programs they can get because it's the broadest range of hospitals, doctors, and all that. So you have a medi-medi situation, Medicare and Medi-Cal. And we'll talk a little bit about that too. So there's other public benefit programs as well. Section 8, you might have heard of before. Basically, that's a housing program. The issue with Section 8 is you might qualify for it, but that doesn't mean you're going to get it. If you qualify for almost all these other programs in California, you will receive a monthly check for SSI if you qualify. You'll receive health care if you qualify for Medi-Cal. You'll receive caregiving benefits if you qualify for IHSS. You could qualify for Section 8, but they're not going to just give you a rental voucher, which is what they give you, a housing voucher. What they do is you might be put on a waiting list, or even worse, they might only open a waiting list periodically to get your name on it. So sometimes it might take years to qualify for a Section 8 voucher. Now, for many people with disabilities, you can ask the local public housing authority if you can get a reasonable accommodation because you're a person with a disability or the person you're trying to get the Section 8 voucher is, and they might bump you to the head of the line. And so there's other ways that they might qualify for Section 8. Doesn't work everywhere, but just understand that there is that nice benefit out there. There's also a veteran's benefit. Again, sometimes the person who's disabled was disabled and they were a veteran. There's other benefits through the VA that they might qualify for. Sometimes they're a child of a veteran. So we look at that a little bit. And then kind of the nicest benefit we have in California that's not really available anywhere else is regional center. And that is from birth to death, public benefits for people with developmental disabilities like autism. And it is there to provide them supports. Now, what it does is it will pay vendors to provide care and such for your loved one with special needs. Again, though, it's huge advocacy. Now, there'll be a eligibility worker, and as most things with government, oftentimes your eligibility workers overworked and underappreciated, and they may not provide you with much service. So sometimes you have to go fight for it. But the benefit of regional center is they don't look at the person's income or assets to determine if they qualify. If you're developmentally disabled in California, you qualify. And so those kind of a nutshell of this public benefits program.
Yeah, I'm going to just chime in for a second on Section 8. I have a really intense interest in low-income housing. I'm a provider of low-income housing. I have lots of tenants with Section 8 vouchers. And just to give people a sense of how incredibly valuable a Section 8 voucher can be in the San Francisco Bay Area. Let's say, you're renting an apartment for about $2,000, which is pretty low in our area. You only have to pay 1/3 of your Social Security check in rent. So you might be paying $300 a month in rent. And then the housing authority, using those Section 8 funds from the federal government, will pay the balance. I mean, it can be an absolutely golden ticket for somebody with a disability to get generic housing in the communities. I just wanted to emphasize that.
Yeah, no, it is a fantastic program. It just oftentimes when I'm doing estate planning, families come to me rather young. So oftentimes my clients don't qualify yet because they have to get on that waiting list. But once they receive it, it is very valuable. Now, I'm going to give you a little primer on public benefits. It's not going to do any justice to the subject because it is just too big for a short little 1-hour program. I do public benefit seminars that last all day. But if you're looking for information on any public benefits, this is the best website I have ever found, Disability Benefits 101. And you'll see that there's different states, and you would just click on California for California, and you can see the website right there. This website is written for consumers. It's written for people who don't deal with public benefits all the time. And it just provides the best, most up-to-date information I have seen. Sometimes I do a lot of writing for periodicals that do updates on legal stuff. And we do a lot of updates on special needs planning. And I'm seeing stuff come right from, the governor's office on public benefits. And I'm writing it into my legal treatises. And I'm going, check out DB 101, Disability Benefits 101, and boom, they've already got it up. Like, I just can't believe how well run that website is. So if you do have information, it goes into everything about Section 8, SSI, SSD, CDB benefits, IHSS. It has tons of great stuff in there. So this is where I would recommend that if you have questions, this might be a very great resource for you. So let's take a step back. So we talked about supplemental security income, remember SSI. And I said if somebody qualifies for it, then they can receive a certain amount of money per month. But you have to really meet two tests. One is you have to be disabled. There's other ways you can qualify if you're aged or other things, but we're focused mostly on the disability. And we'll talk about what that means in a minute. But you also, in addition to being disabled, you have to be poor. And they have a resource test, meaning they count how much stuff you own. And if you exceed that resource test, then you lose the benefit. And then there's an income test. And when we talk about income here in a minute or two, your people in their minds, I know what they're going to think. IRS income. It is different for public benefits income. They have different rules, and we'll go over those. And a lot of times this is where people screw this up, is they sometimes confuse the resource test with income, and then sometimes they don't think something's income because that's not what the IRS counts as income, but the Social Security Administration will. So let's assume that we qualify. What do you receive? Well, currently in this year, if you receive maximum SSI as an individual, you'd get about $1,040 a month and some change. And basically, depending on income and other things, that check may go down. And we'll talk about some of the ways that that check may be reduced. Also, if you're a married couple, you actually get a little more money. And then sometimes the check gets a little confusing because there's exceptions if, say, the person lives in a housing arrangement that has no kitchen, you might get a little more money. But generally, this is what most people who are individuals and are disabled receive per month. And each year they do a cost of living adjustment. And I know I just looked at what our cost of living adjustment for 2023 is. It's one of the biggest, I think, in over 20 years. I want to say it's 6.8% or something close to that. So this number will go up significantly for next year. And the thing to remember about this is there's a federal portion of the check, and then California supplements that check. So the federal government pays about $879, almost $880 a month, and California supplements it. So that becomes important on some of our other issues, but for your purposes, the idea is how much money can they receive? But what do they mean by disabled? So sometimes people think of somebody in a wheelchair as disabled, who they use a wheelchair for mobility. But if that person is able to go out and say work at Apple as a programmer, the federal government will not consider that person disabled for public benefit purposes. So the reason is that disability has to prevent the person from engaging in what they call substantial gainful activity. And that's just a fancy way of saying that they're not able to go out and get a job doing anything and earn, I think it's around, I want to say $13.50 a month, doing anything because of a physical or mental impairment that will last for 12 months or longer. So there's a couple of steps in there. They have to be disabled. That has to be last longer than a year. And that disability prevents them from working and earning. And it doesn't matter if there's no jobs out there. It just matters, do they have the ability to work? And if they don't meet that definition, then they don't qualify for SSI. But if they do qualify, then we have to go to, remember, there's two tests. That's the disability test. Now we have to see if the person's poor enough to get SSI. And this is tricky because they gave us $2,000 for an individual, meaning that for countable resources, if they have more than $2,000 in their name, they are disqualified from SSI. And I think that that number was selected in 1973 under President Nixon, and it has not been indexed for inflation. And I know there's pending legislation out there to try to get this number increased, but we don't know if it's going to pass or not. So this is what is tricky, because if you want to leave money to somebody on SSI, if you leave it to them in their name, it will disqualify them as a resource because it's over $2,000. And again, there's $3,000 for a couple. And so if somebody's on SSI, their spouse and them combined can only have $3,000. Now, when we say countable resources, not everything is counted, and that includes a house, the primary residence, one automobile, and furniture, clothing, personal care, and then some weird things like burial contracts and life insurance and stuff. So again, there are some assets, really the house being the biggest, the car usually being the second biggest, and then personal care items, like furniture, stuff you need in the house. So that's the resource test, and it's kind of easy. 2,000. If you are over 2,000, you've lost it. If the harder test is this income test, and there's really four kinds of income for SSI purposes. One is earned income, which is kind of like the IRS definition, but then there's three kinds of income that aren't really counted like IRS income. There's unearned income, which is the worst. In-kind income, or sometimes called in-kind support and maintenance. And then there's deemed income. So if we look at earned income first, basically what they'll do is the Social Security Administration very generously lets you receive $20 of any income, and they won't count that against the SSI recipient. If the person goes out and earns money, they can also add on $65 of free income, earned income. And so for every $2 earned above, say, $85, they lose $1 from their SSI check. So remember, if the check is $1,040 a month and they earn a certain amount of money, for every $2 they earn, they lose $1 off that SSI check. So my example makes it very clear, like they earn $585 in 1 month. The SSI check is reduced by $250, right? They get the $85 of exempt income, and then it's a $2 earned, $1 loss. And basically they end up with, extra money, but not as much money as they would if they went out, and didn't have this public benefit and lose it. Now, this is the default rule for income. It's critical that everyone remember that once somebody's qualified for SSI, the Social Security Administration does have some right to work programs, ticket to work. There's a PASS program for achieving self-support. So there are different ways they can earn money and still keep their benefits, or maybe not lose them as drastically. But this is the default rule. And so this is earned income. So remember, earned income, for every $2 earned, they lose $1. Now we got the toughie, unearned income. What is unearned income? Unearned income is like if you give somebody who's on SSI $500, basically they will reduce that dollar for dollar from SSI. So Social Security says this is a program for poor people. And if people start handing money to somebody who's an SSI recipient, we're going to disqualify them by reducing their check dollar for dollar. Now, remember, we get that valuable $20 exemption. So you got to take $20 off, but they lose $1 for every dollar they're given. And that could be a gift. It could be an inheritance that they receive in their name. It can really be lottery winnings. Anything that they get in cash is unearned income. So this is really tough. And a lot of times parents who may not be as familiar with these rules will, maybe their loved one's getting $1,040 a month. They have to live off that in California, and they're paying for their food and shelter and utilities through that $1,040. And so they're like, well, I'm just going to give them like a $500 allowance to give them some more spending cash, and not realizing that Social Security will treat that as a $480 reduction off their SSI check. And a lot of times Social Security won't catch it right away. And so 5 or 10 years later, they figure out that you've been giving them $500 a month for however many years or months. Social Security will come back and they want their money back. And so they'll do that through something they call an overpayment. And they'll go, I want my 480 times however many months that you were giving them $500. So a lot of times when families come into the office, that's one of the things we talk about, just can't give them an allowance. Now there's a way to support somebody on SSI without interfering with their SSI check. But I just want you to know, giving them cash is never a good idea. Another really tough type of income from Social Security is called in-kind support and maintenance. So this is if somebody's receiving SSI and somebody else provides them free food or shelter. And what the Social Security Administration seems to say is if somebody else is giving them food or shelter, then why should the government continue to pay all the money? Because that's what they think SSI is for, to pay for that person's food or shelter. So if somebody's giving it to for free, we're not going to let you have the whole check. Now, they don't reduce it. Remember, earned income, what the person, SSI recipient, earns, every $2 they earn, they lose $1. Or they don't treat it like unearned income, which is every dollar given to that person with a disability or an SSI, they lose $1. So it's $1 for dollar. ISM, or in-kind support and maintenance, free food or shelter, what they do is they reduce the check by 1/3 of the federal portion of the check. Remember how I said there's a federal portion and a California portion? So they reduce it by 1/3 of the federal portion, which roughly in our in 2022 is about $300 a month. So if you paid for the person with a disabilities and they're an SSI recipient, and you pay for their rent or their utilities, it's going to reduce their SSI check by around $300 a month. Now, oftentimes, we're going to trigger that penalty intentionally because we're going to give up the $300 a month and make sure the person has a clean and safe place to live. We might pay $2,500 a month in rent. Once you trigger the penalty for food or shelter, then you can pay for all their food or shelter with no further penalty. So the maximum they lose is that $300 a month. They don't lose any more by paying for a much nicer place to live. So a lot of times we trigger that on purpose. But again, you have to kind of understand what you're doing with that. And then the other weird kind of income is called deeming, SSI deeming. And this is where a lot of times families will come into my office and they'll say, well, my child has severe autism. I don't see why they're not disabled, and they certainly don't have any money. So why are they not receiving SSI? And the reason is until they're 18, until they're an adult, they will count the parents' income and assets as that minors. And so that's where we focus on, mom and dad's income and assets. Now, it doesn't mean like mom and dad actually don't have a lot of income or assets. It's possible that child could still qualify for SSI, but that's rare. It's most of the time if a parent has more than $3,000 of countable resources and income, it would disqualify them from SSI. When that loved one turns 18, they only look at their income and assets. Okay. Now, another type of deeming is spousal deeming. So if that loved one gets married and their spouse has income or resources, those are also counted against them. So a lot of times somebody might get married and get knocked off SSI, or sometimes what they do is, they marry someone else who's on SSI and then it works just fine usually. But again, it's something that should be figured out in advance, whether or not what the impact is of somebody getting married. Okay, so that's SSI in a nutshell, I will tell you. And I mentioned before, Social Security Disability, SSDI, is the one that they don't care about your income or resources. So all that stuff about deeming, unearned income, in-kind support and maintenance does not apply to SSDI. But you can only qualify for Social Security Disability if you yourself paid into the system for sufficient quarters. Now we'll talk a little bit about a children's benefit in a minute, a child with a disability, and there's spousal benefits as well. But in general, you're looking at your work record. And if you think of it this way, you're basically buying a disability insurance program from the government when you go to work and you see on your W-2 SSD. That's the premium you're paying for this program. Now, there's no resource test. And again, if you're on Social Security Disability for more than 24 months, you can qualify for Medicare. Now, sometimes, depending on how long you worked and how much you paid into the system, that tells you how much money you're going to get from Social Security Disability. And they treat Social Security Disability for SSI purposes, supplemental security income purposes, as unearned income. And so for every $2 of SSDI, it knocks $1 off your SSI check. But let's say you only worked a little bit into the system before you became disabled and you didn't pay in a lot. And so your check for SSDI is like $500 and you're getting the full $1,040 for SSI. In that case, you'd be getting both SSI and SSDI. And then remember, with SSI, you automatically get Medi-Cal. And after 2 years with SSDI, you can get Medicare. So I have clients sometimes who have SSI, SSDI, Medi-Cal, and Medicare. So I just want you to know that's how these kind of work together. And again, we're focused a lot on our planning and making sure that we're not interfering with this eligibility for benefits. Now, this is that program that I think a lot of people miss. And this is an it is under the Social Security Disability, but it's called the Childhood Disabled Beneficiary or Disabled Adult Child Benefit. And basically the person has to have been disabled before age 22. And as long as they never got married, that's one way to lose this benefit, is if that SSI recipient gets married, they lose it. Horrible. And then the other way is if they're able to engage in that substantial gainful activity, like if they go out and work on their own, they're also ineligible. But for a loved one with special needs who was never able to work, was never married, and was disabled before age 22, when the parent retires or becomes disabled, they get 50% of the highest parent wage earner Social Security check. So that's a pretty cool program, because a lot of times 50% of what a parent earns is much higher than the $1,040 a month they're getting from SSI. It would knock them off SSI, but they're getting more money. And again, like Social Security disability, this benefit doesn't have those income rules of worrying about food and shelter or unearned income. You can't screw this benefit up by helping that loved one out. And then after that parent dies, they can qualify for 75% of the parent's check. And it doesn't take money away from the parent, it's in addition to. So if the parent's receiving $2,000 a month from Social Security disability, the child would get $1,000 a month, while they're retired. And
Kevin, I want to interrupt because I think this is super important, and I just wanted to interject for a minute. We're seeing, unfortunately, the aging of the autism parent population, and I'm seeing more and more autism parents dying, to be quite honest. And most of their kids get SSI, and then there's this transition to what you're talking about here. How does it happen? Does who applies to SSI? How does this technically? How does the transition occur? And how soon can they get the additional benefits?
This is where advocacy comes in, because this is why I have had so many parents who've been retired come in to do their estate plan, and their child should have been receiving this benefit for years, and no one applied. Because no one at Social Security is going to come out to you and say, hey, guess what? You're qualified for. So you kind of have to know about it. Now, sometimes you might run into a sympathetic social worker or a sympathetic worker at the Social Security Administration who might tell you to apply for this. But all too often, parents just skip it. And until you apply for it, they will not go retroactive to when they qualified. So you get the benefit from when you apply for it. And then it takes a little while to run you have to go through their process, but then it's retroactive to the date you apply.
And what is the age for the retirement? So when parents are retired,
it's whenever they're getting the Social Security check. So they may decide to take late to get a higher check, or they may go as early as possible just to get it going. Again, a whole nother program on when you might want to trigger your own Social Security. I've had a few parents go for early retirement just to get their kids off SSI into this program. But again, that's beyond the scope. I don't want to say do that, because it could be completely different depending on your situation. You might do much better if you wait and get a much bigger check, because it's over a lifetime, right?
Right. Okay, thank you.
Yeah, it's a really cool benefit if they qualify for it. And again, it's real tricky sometimes, because sometimes your child might work for a period, but they have a supported work arrangement. And a lot of times Social Security will tell you don't qualify because of that. But a lot of times they're wrong, because it's not so much that they worked, it's that they had substantial gainful activity. And if they had a job coach and supports, that's not the same thing as working on your own without that support. So you can advocate for this program, even if your child has worked, as long as that work was supported. Or it could have been a sympathetic employer who just let them work, but kept them on, not because they did a great job, but just because of their disability. So again, there's lots that goes into this, again, beyond the scope, but I get really excited about it, probably me and no one else. Again, Medicaid and Medicare, one slide, it's a huge deal. It's health insurance. Again, Medicaid is the national name for Medi-Cal, what we call in California Medi-Cal, and it basically covers just about everything. One of the things to remember about Medi-Cal is that it is the only place where you're going to find in-home caregiving covered. Medicare generally will not cover that. The same thing with skilled nursing care, sometimes called nursing home care. That's where Medi-Cal will pay for. Medicare has a short time frame that they'll pay for that, but it won't pay for any long-term skilled nursing care. So oftentimes, even if they may not use Medi-Cal that much, we still want it sometimes for the in-home supportive services because that's where it's paid for, or the in-home or the nursing home level care. So again, public benefits is important because a lot of times when we're doing an estate plan, what are we doing? We're planning for someone who's not able to work and earn their own money because of a disability. And so we're trying to find as many sources of revenue and care that we can for that person for free. And that's why public benefits is just so essential. And then we try to set everything up for the person doing the estate plan. We'll talk about in just about 2 slides here. Again, to remember about Medi-Cal, you automatically get it with SSI. And there's one of the Obamacare programs is called Magi Medi-Cal or sometimes expanded Medi-Cal. And they don't have a resource test for that, but as long as their income is below 138% of the federal poverty limit, which is a chart that you can Google and it'll tell you what that is based off how many people are in the household. I want to say around 14 or 16,000 a year. If you're below that, you qualify for Medi-Cal in California. And then Medicare, remember, is available if you have Social Security disability or that childhood disabled beneficiary benefits for 2 years, then they can qualify for Medicare. And it's possible to have both. One of the big things that's happened recently with Medi-Cal is, remember SSI has a resource test of $2,000 and $3,000 for a couple? That used to be the same resource test for Medi-Cal. But they recently changed it so an individual can now have 130,000 of countable assets and still qualify for Medi-Cal in California. It's the only state that has that. Every other state pretty much is still at the 2,000 limit, but in California it's 130,000, and for every additional person in the household it's another 65,000 on top of that. So again, they still have an income test for Medi-Cal. But again, access to Medi-Cal is getting easier for people with disabilities to qualify for. All right, and then if you're this is the federalhealthcare.gov. I think we have our own in California, but it's just, again, one of the ways that you can go out, and just because somebody's on Medi-Cal doesn't mean they can't have a private health plan. And sometimes we do get the private health plan because that person with a disability, they might need services that are only available through a private health plan. Medi-Cal may have services available, but no providers. So again, we're always on the lookout for how are we enhancing the quality of life of that person with a disability, and paying a healthcare premium might be one of the ways to do that. All right. So now we're all experts on public benefits. So again, I want to remind everyone, there's a lot there. There's a lot to unpack on public benefits. Don't be overwhelmed if your mind is spinning, because everyone who looks at those public benefit programs and all these weird rules, their mind spins. It's just one of those things. It's real complicated. There's a lot of exceptions. There's a lot of rules. But if you understand the basic premise, the basic concepts, it's important. And then if you have a specific question, remember there's always DB 101, Disability Benefits 101. Google that, it's your friend. There's a lot of great stuff there. All right, so now we go into the plan. So again, I'm an attorney. I spent, almost 30 years now doing planning for people with disabilities. And things have changed a lot in 30 years, I will tell you. But one thing that has been almost consistent is setting aside money for a loved one with special needs, so we don't screw up all those benefits like SSI, Medi-Cal, IHSS. And we want to make sure it's set up in a way that is protective of that person with a disability. And so we have tools for doing that. Now, one of the things to think about is if your loved one has turned 18, one of the things to remember is you as the parent have now lost the legal right to make decisions on their behalf, healthcare, personal, financial, where they live. Does that mean that no one's going to listen to you anymore? No. Most of the time, people will listen to you, but you might find that the doctor won't release medical information for you. Or if you're in an IEP and your child says, I don't want my parents here, you're out of the room. So you have to remember that when they turn 18, no matter how severely disabled they are and incapable of communication, legally, you've lost the right to make their decision. Now, if they have capacity, which is one of those fun words that doesn't have a very strong black and white definition, but if they basically understand the concept of a power of attorney or what we call an advanced healthcare directive, basically what they can do is appoint someone legally to make decisions for them if they've lost capacity or even if they have capacity. And so that might be where you have them fill out a power of attorney form. And basically they would name parents as agents or, siblings, relatives, friends, just people that they trust to help make decisions on their behalf. Same with the Advanced Healthcare Directive in California. It's a great way to, frankly, I think any child who turns 18 should probably do this, but it's really important for children with disabilities. Now, what happens if they don't have capacity? Like they just don't understand, they may not be able to communicate at all. Then we're looking at a conservatorship. It might be a limited conservatorship or a general conservatorship, depending on, if they have a developmental disability, which most people in this audience would probably have autism, which would be a developmental disability. So they might then qualify for a limited conservatorship. Basically, you go to court and you ask the judge for permission to continue to make decisions on their behalf. There's usually a court investigator that comes out and does an interview with a person with a disability and their proposed care conservators, the person who's going to make those decisions. The regional center will issue a report whether they think this is in their best interest. An attorney will be appointed, required that they be appointed for that person. Usually, sometimes it's a public defender or somebody else appointed by the court. And there's a hearing. And the judge will decide whether or not that limited conservatorship should go forward. So it's kind of a big deal because we're taking away that person's civil rights. And unfortunately, thanks to the Free Britney movement, getting a conservatorship is a lot harder than it used to be. And sometimes it's needed. And we still have to jump through some additional hoops to get there. And so remember that there is that option. Now, does that mean that if your loved one has no capacity, you should rush out and get one? Again, I don't think that's necessary unless you're having some kind of issue. And if you are and you've waited, there is something called an emergency conservatorship that you can get usually within a week or sometimes sooner, depending on how severe the emergency is. But again, it is important because it is more powerful, I think, than a power of attorney and the Advanced Healthcare Directive, because you have a piece of paper called letters of conservatorship that have a stamp on them. And basically, it's a wonderful way to, say, no, I still have the authority to make decisions. Now, managing a child's money, a loved one with special needs money, that's where we talk about the special needs trust. I gave some options here on the powers of attorney. Again, you have to have the capacity to understand the document. And the other downside of a power of attorney is that person who set it up can also revoke it at any time in the future, as long as they still have capacity. And there are certain requirements for execution. So sometimes people sign something, I hereby appoint so-and-so to be my power of attorney. No witnesses, no notary. That's not good enough in California. That doesn't do it. If you Google uniform statutory power of attorney, there is a California statute that has a power of attorney form you can fill out. You can initial which powers you want. You can initial one line that gives you all the powers. It's not bad, but it also sometimes doesn't cover all the situations that you might need for a loved one with special needs, but it's better than not having anything. So I usually send that out to clients if they want to get their loved one, they may be moderate or high functioning. And we want them to have some authority, the parents to have some authority to come in and help make decisions. The Advanced Healthcare Directive, again, is the healthcare agent. That's where they can't make healthcare decisions on their own. And again, you can pick and choose the powers. And frankly, we just had a law pass on supported decision-making, which is another alternative to a conservatorship. It's something in between the Advanced Healthcare Directive, the power of attorney, and a conservatorship. So supported decision-making is saying that the person might need assistance with making decisions, but we're not just giving away their authority to make any decisions themselves. They want assistance, support to make those decisions. So again, there are options here. But coming to
I should say, just for our audience, this is a conference focused on those with more significant cognitive impairments. It's pretty seldom that I find an adult child who has the cognitive capacity to make the knowing delegation of authority in a in a power of attorney, for example. And most often when parents use it, I'm being honest here, being brutally honest.
It's just us, right?
It's just us and a couple hundred people watching. I question whether or the child really had the capacity to sign that document knowingly, understanding its contents. I'm just putting that out there.
Yeah, no, that's very important, because if it's found later that they didn't have capacity to sign the document, then the document's worthless. It has no value. Usually with, I've had clients come in, well, I think my loved one has capacity, and I sit down with them, and any good attorney will kick everyone else out of the room except for that loved one with special needs and interview them. And then you make notes and you ask them, do you understand it? And then you kind of go through some scenarios, and pretty soon, at least as an attorney, you kind of get a sense if this person's really getting it, or, they're just repeating to you what you're saying to them, or sometimes they just absolutely cannot communicate. And you're just like, an attorney would not, well, let me rephrase. An attorney should not allow that document to be signed. So yeah, there is certainly, and that's also why I think it is not as well respected out in the world as a conservatorship, because, with a conservatorship, that person's been vetted by, there's a doctor's report, there's a regional center report, there's the public defender, an attorney defending them. So that they've been through the ringer, basically, to make sure that conservatorship is needed and necessary and for their benefit. So yeah, you make a good point. But again, I work with a lot of clients, and so some of our clients have purely physical disabilities. I have no problem doing it for them. And then with a developmental disability, it's harder. All right, so let's talk about special needs trusts. So what are they? Basically, it's a way to leave an inheritance to a person with a disability. Primarily, a lot of times it focuses on making sure that it does not interfere with those public benefits, right? We don't want the public benefits to disappear because of countable resources or some of these income rules. And so all the money held inside a special needs trust is exempt, and all the income earned inside a special needs trust is exempt. Okay, now we call it a third-party special needs trust because it's being funded with assets of anyone else on the planet other than the person with a disability. And so third parties can fund that. And so it's important that we make that distinction, because there's a different kind of special needs trust called a first-party special needs trust. And I see way too often people are screwing up the rules between the two kinds of special needs trusts, and they're making this trust much more restrictive than it needs to be. Now, a lot of times, this doesn't happen as often anymore, but early on, the advice given to a lot of parents of loved ones with special needs were to disinherit the person and maybe leave the money to a sibling, or any one of these things. And none of these options is really ideal, because let's say you disinherit them, there's no money, right? And the only thing they have left is that public benefit that could be that $1,040 a month minus whatever help they get from other people. And that's not great. I mean, try living anywhere on that. It's crazy. I mean, I know there's people who do it, but most of my family wouldn't want them to live in that kind of environment. So they go, well, I'll just leave it to their brother or sister, and they'll promise to take care of their loved one. And even if that brother or sister has, the best intentions, they're not, immune from things happening to them. So they could end up, I always say they could end up being distracted, run a stop sign, hit a bus full of plaintiffs' attorneys, and have huge creditor problems. All the money they had to set aside for their sibling with special needs is gone. Or they could get divorced, and it might have got wrapped up into their marital assets, and half of it is gone. Or they could die themselves, and maybe the money all went to the spouse who has no interest in caring for their in-law. So it's not really a great way to leave money, because if you leave it in a special needs trust, it is legally set aside for that loved one with special needs. Okay. Now, when we're setting it up for mom and dad, when they come in, we want to make it revocable, meaning that mom and dad can always modify the terms, as they get older. So a lot of times they come in young, and then every 3 to 5 years, they may look at it and go, maybe need to change some names, change some people who might inherit after a loved one dies, stuff like that. Once the second parent dies, then it becomes irrevocable, meaning that they can't change it. And that does one of the rules for this trust is the person with a disability can never have the right to revoke the trust, because if they have that right, the trust becomes countable. Now, there's 2 ways to set these trusts up. One is inside your own will or living trust yourself. So that trust would not come into existence until after you die. And that would be called a testamentary special needs trust, which works just fine, except I like doing what we call a living special needs trust. So while mom and dad are alive, or mom or dad, we set up their living trust, their will, and we set up a special needs trust where the parents are in charge of that trust as trustees, but usually there's no money in it. It's just sitting there, and then in their document says, on our death, put the money into that trust for our loved one. But the reason I like having it set up now is twofold. One is, if there's other family members who want to leave money to that loved one, that living trust is in existence and can accept funds. That testamentary trust is not in existence until the second parent has died. So you want to have some place to put that money. Otherwise, grandma might leave money directly into the name of that person with special needs, and that's unearned income. They lose benefits. It's a resource. So it could cause problems. The other reason is a special needs trust might last for many decades of administration, which is what we hope for, because that means money's being set aside to enhance the quality of life of that loved one with special needs. And I want all of those provisions set aside in a separate document, so it really explains how to use those for that loved one. So again, I think it's critical to do, but again, you can set them up either way, but I like that separate living trust. The other thing to remember about a trust is that we're trying to kind of replace the parents in a way, because mom and dad are now gone and they've been doing everything for that loved one with special needs. So who is that person to take over? Again, they have to understand all the laws necessary to manage a trust, which is, set forth in the California Probate Code. They have to understand all those public benefit rules we just went through. They have to understand that that trust is set up for that person with a disability, and they cannot engage in what they call self-dealing, which a lot of times looks a lot like just running the money like mom and dad would have, but it might be different if the trustee is managing it. They can't favor themselves over their sibling or whoever the beneficiary is. They have to understand how to invest money properly. And again, that is a unique thing for people with special needs as well, because a lot of financial advisors are focused on somebody's working and then trying to invest on the side with that. And with special needs persons, a lot of times they can't work because of their disability. So it's almost like creating a retirement plan for an 18-year-old. And so you have to be very careful how you invest special needs trust funds, and then also accommodate the public benefits and trying to incorporate that. So that's why there's specialist attorneys who do this, special needs planning attorneys, and there's specialist financial advisors who do this, because again, this is not what most financial advisors or estate planners would see. So the other thing the trustee has to be aware of is tax decisions on property, and there's employment taxes. You have to keep perfect books and records because Social Security will come back and audit these trusts from time to time. It's a good idea that if that trustee makes a mistake, they have to understand they're liable for that mistake, even if it's merely negligent. They didn't intend to cause any harm, but they could still be held responsible. They have to be able to understand abuse. They have to understand second-rate service and discrimination against people with disabilities. They have to understand real estate laws and housing and insurance and mortgage if there's one existence. Care managers and caregivers are, again, one of the hardest things to do. So if somebody's on IHSS, could you supplement their pay? Because they're not paid great by the state. But again, one of the rules is you can't supplement an IHSS worker's pay. Otherwise, it's a problem. You could hire them to do other things, but you have to hire them as an employee, not an independent contractor. So you see, there's a lot of rules there. And then it's also helpful if that person's a great communicator and is firm but kind, but also able to say no. Because that's how a trust works. A specialist trust works is the trustee has the legal right to say no to distributions. And that's why Social Security won't count it as an available resource. But the trustee has to know, well, I can't say yes to that because I know that'll cause a problem. Okay. It also helps if they're psychic, immortal, and omniscient. So again, trying to find that ideal trustee is nearly impossible.
Yeah, when you find somebody with all these qualities, will you let me know?
Usually what we decide to do is to try to break this up into different roles, right? So let's get the trustee. I like to use private professional fiduciaries. So in California, we have this wonderful resource that not very many other states have, and that's a licensed profession called under the Bureau of Professional Fiduciaries. So these are individuals, and some of these individuals specialize in being trustees of special needs trusts. And so I like them because they understand the rules. They don't have to go, they don't have to learn all the public benefit rules. They don't have to know how a trust works. Again, a lot of these things are extremely important. And it's very easy for a family member to get lost in these rules, not respect the rules, or even try their best and still screw them up. So I liked having a professional. Where I put the family is on something called a trust advisory committee. And basically it's all those family members and friends who have the loved one's best interest at heart. And I let them decide who's going to be that professional trustee. And if they don't like them, they have the right to fire them for any reason. Okay. So that way, oftentimes families will come in and say, well, the sibling will be the best trustee. But then you're like, well, what if that sibling, who might be 10 years old when we're talking about them, but I go, by the time they become trustee, they might be 25, 30, have their own family, their own children. They might have moved out of state. And now you're giving them all of this responsibility. I mean, they have to understand all of this. Why not put them on an advisory committee, have them hire a person to help manage a lot of those things, these people who understand investments, they understand employment, they understand trust laws, let them run the money piece. And then you just make sure they continue to do a good job. And then they have the right to remove and replace them. And then oftentimes I'll add a trust protector role, because remember, this trust will last for decades. Who knows what Congress is going to do in 15 years, 20 years, 40 years. So I want to make sure that my trust is irrevocable at some point, that there's an easy way to update it with any changes in the law. And that's what a trust protector can do. And so the advisory committee can appoint someone to make an amendment that keeps it current with any change in the law. And then the trust protector can resign and we just keep going. The alternative is you have to go to court, petition a judge. The judge will say, probably that's fine. And now you spent $3,000 to $5,000 to get that petition. Again, I like this management team because there's a check and balance and there's multiple people doing different roles. And one of the things that you can do, you can find special needs planning attorneys in your area and financial advisors at this website, specialneedsanswers.com. Again, it has a whole host of other things there, but if you're interested in finding a planner close to you, you can do this, enter your city, state, or zip, and there's a whole list of planners. Oddly enough, I chose Berkeley, and you see me there with my associate Jess. But again, anywhere you're located, and again, there's attorneys in almost all 50 states. So it's a great resource, attorneys and financial advisors in almost all 50 states. The other big thing is a memo of intent. So the special needs trust is a very basic document at its heart because we don't want to make it inflexible. We want to make sure there's room, because who knows, who can look into the future and guarantee that they're still going to want to go to the summer camp. So you don't want to write in your trust, pay for this summer camp every year, because that may not be smart in 30 years. But if you lay out in the trust, enhance their quality of life to the maximum extent possible. And the memo of intent, what you can do is say, you know, I'd really like to encourage the trustee to pay for summer camp, and I'd really like to encourage travel. And again, the memo of intent is the most underutilized and most important document that you can prepare. And again, when mom and dad are taking care of that loved one and now they're gone, we have lost so much information. And siblings don't know it. They may know some of it, but they're not going to know everything mom and dad know. So if you can get that on paper, and then that is so helpful to that trustee, the trust advisory committee, it is so critical. And because so long, I've been telling my people that we need to get them to do memos of intent, and they hardly ever did, because I will tell you, it is hard. It is not an easy thing to sit down and write out everything you know. And so my wife and I, we have a daughter with autism, and so we created a workshop to help parents in creating a memo of intent. And so here at our website, movingtomastery.com, you create an account, log in, and you can just do a 1-hour workshop on a memorandum of intent. Inside, there's some guidelines on things to consider, but there's also fillable PDFs to get you started. And I found that once I had the memo of intent workshop going, a lot of times I would get my clients to actually send me memos of intent. Trust me, this is the document that that trustee, the siblings, advisory committee will look at a lot. And in there, you'll notice one of the things we recommend is on that child's birthday, pull that memo of intent out, update it, put it back in your file, you know, send a copy to your special needs trust attorney so they can have it in their file. Again, very critical. I know we're running out of time here. So there's an ABLE account, and I know there's other programs that were taught just on ABLE. Just understand that an ABLE account is another way to leave money, or the person with a disability can actually control an ABLE account if they have capacity. Generally, they have to be disabled before age 26. California has the Cal ABLE plan. You're only allowed to fund it up to $16,000 a year. It's based on the annual gift tax exemption. So that might go up $1,000 every 2 or 3 years, but right now it's $16,000. Everything grows income tax free. If you make distributions for what they call qualified disability expenses, they come out income tax free. The IRS, for whatever reason, which is the agency that runs ABLE accounts, much more generous than the Social Security Administration. So qualified disability expenses is really broad. I mean, it can include just about anything. I think maybe gambling losses might not be qualified disability expenses, but gosh, it's hard to think of almost anything else that the IRS hasn't said is authorized. The account can grow up to 100,000 before it interferes with SSI, and SSI would only be suspended, not eliminated, and then the money can be spent down, and then it's just reinstated without having to reapply, which is a real benefit. You can move from state to state, and in California, California has stated that they will not recover against assets in an ABLE account, which they can in almost every other state. So, which means that if you use Medi-Cal or Medicaid in another state and you have an ABLE account, that state can go after assets on death. Otherwise, the assets go to, you know, the heirs of the person with a disability. Pretty neat little account. And we talked about conservatorship and losing their right to make decisions. So sometimes a conservatorship is necessary. So here's what we talk about is And it's a hard conversation, but it's important about envisioning your loved one's future, like where and with whom are they live, what kind of care. Will we need a conservatorship when they're 18 or older? Who else is going to be involved and at what role? So sometimes we might need successor conservators, we might need trustees, trust advisory committee members. Depending on the assets, we have to look at the lifestyle, and then possible future challenges. Are they going to be able to live independently at all? Is there any option for that? What's that going to look like? Will we need a board and care? So again, these are all steps that we consider when we're doing a special needs plan. And again, it's usually a plan that you set up and then you look at several years down the road. A third party special needs trust is, I think, the primary planning document. That's where all the legal stuff is. And it kind of drives, the memo of intent, and it can help with the conservatorship and all kinds of things. It's a really great tool for people with disabilities. And then I've talked about the importance of a memorandum of intent, why I think that is so important. It's just the greatest document that I've seen used in this type of planning. Usually when I get done with my piece, which is this, mom and dad will say, well, how much should we put in that trust for their lifetime needs? And that's what a financial advisor is good for. So you see my incredibly complicated formula: income minus expenses equals the shortfall. So a financial advisor can really help you. And a lot of times financial advisors, one of the better ways to kind of set up a plan is a second to die life insurance policy. But the thing to keep in mind is that you generally need a whole life policy, not a term life policy. I've heard these horror statistics that, like, with term life, which means like you paying a very small premium for like a 20-year term, they've got it figured out that I think 99% of those never pay off. They know you're going to survive that 20 years. They're just accepting your premiums. And it's just that 1% that pay off. So it's not a good funding tool for a special needs trust if you definitely want that money set aside. So a whole life policy is you're investing the money. Usually the premiums are higher. And so again, just things to keep in mind when you're doing that.
Yeah, we consulted a financial advisor and many years ago bought whole life second to die life insurance policy that's held by the special needs trust.
That's the best way. It's setting up assets for them. And remember, you have to focus on yourself too, your own retirement, your own needs for care. And oftentimes the most money you end up spending is like the last 1 or 2 years of your life. So even if you have a fairly healthy portfolio, sometimes you have to really focus on making sure there's money set aside for that loved one with special needs. And I mentioned before, if the person with a disability ends up with assets, there is something called a first party special needs trust. This is the one that the government does not like. I'm just sure of it. I'm just guessing, but because they made the rules so hard on that trust, basically it can only be set up by certain people. It has to be for their sole benefit. It must be for someone, has to be funded and established before age 65. But the real kicker is the money can stay in trust for their whole lifetime, but on their death, any money left in that trust has to be used to pay back Medi-Cal on any services they received throughout their whole life. So a lot of times the money goes in, you can preserve public benefits, but on the death, all the money ends up with the government, which may not be what mom and dad want, which is why the third party trust is so much preferred, because on death, the money can stay with the family. It does not have to go to the government. It's a big distinction. And it's why people plan in advance. I will say that on the second bullet, it says established by parent, grandparent, legal guardian, or the court. An individual can now also set up their own first party special needs trust, which they couldn't before, I think, 2016. A couple books that I've helped write. One was Special Needs Trust through the Nolo Press. So I do a lot of consumer seminars, and usually at the end of that consumer seminar, people would ask me how much money I charge to do this planning. And I would tell them, and they would say, half the room would say, wow, no problem. And half the room I could say, there's no way I can afford that. So if you look at the Nolo Press, that is a do-it-yourself special needs trust that you can leave assets to. You can prepare it yourself. There's a form in there. I think they have an online form we can download and fill it in. So it's a nice, solid special needs trust. It probably doesn't have a lot of the bells and whistles that we've talked about, but it will preserve eligibility for public benefits. I think we've even set it up so you can create an advisory committee and other things. So there is a way, and at a minimum, you might want to read it just to make sure that your attorney is, hitting all of the points that are identified. Because a lot of times, estate planning attorneys focus on that public benefits issue, and they don't think about caregiving, housing. They don't look at long-term advocacy and replacing trust advisory committee members and trustees. So they're used to this estate planning world, which is similar but not the same as special needs. And then the other book is Administering the California Special Needs Trust, which I kind of wrote initially just because I kept getting questions like, what happens if I'm the trustee and I'm paying for a coat? Or what if I pay for food or shelter? What's the impact? And so I did a question and answer thing, and I thought it might be 50 pages, turned into 600 plus pages. It is written question and answer. It is written for consumers. And again, parents might find it valuable too, because really, if you look at it, a special needs trust is treated the same thing as a parent for, a loved one with, if they have a child with special needs who's on, say, SSI or Medi-Cal. And it talks about what you can and can't do as far as giving them cash, paying for food or shelter, buying them things. So what you can do is pay for things directly and give them the service or the good, but you can't give them cash to allow them to buy the service or good. And you can't reimburse them if they went out and bought something. So there's like just weird rules. And I try to remind clients, don't use your common sense, please, because these rules sometimes make zero sense. And sometimes people are like, well, I'll just do it. I know I'm not trying to screw this person over. I'm not going to get impacted. That's not true. I mean, the best, most well-intentioned people can get into trouble real easily. So these books are available online, or my office if you're interested. But again, I think they're very helpful to get through some of this additional stuff. So that's my contact information. If you have any questions about this, I'm happy to help. I also do a monthly newsletter. So if you go to my website and it's on special needs planning, it does updates of, pretty much every one of these issues that we've talked about. So.
Great. Kevin, that was great. And everyone, you're going to get a quiz on all of that. Oh my gosh. Listen, I went to law school. I have a law degree and my head always spins after I hear these presentations. Kevin, thank you so much. We have to go, but that was great information and we will get this posted shortly. Thank you for participating in our conference, both in person and after the fact.
My pleasure. Anytime. Happy to do it.
Okay. Thank you.
Thank you.